code enforcement manager. First case we're gonna have is,
Before we get started, I have to go ahead and do my introduction and get everybody sworn in. All right, we ready to get started?
Yeah.
All right, good morning. My name is Myrna Roche. I'm going to be your special magistrate today. This is a quasi-judicial hearing, which means this is like court that we see on TV or if you ever attended in person. However, the rules are less formal, and everybody who's here to speak in regards to a case will have the opportunity to do so. At this time, anybody who's going to be providing testimony, please stand up, raise your right hand for the taking of the oath. Do you swear from the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yeah.
All right, with that, I'm going to ask the city to please call the first case.
first case, the respondent is Bruce Clevenger. It's an overtime meter. And the base officer is David Scott.
Got it.
You ready to present? Nobody's.
I can't hear that mic at all.
So there's no
And the gentleman next to
attorney for us
Kristen,
or in here?
I can hear him
have
and he's
it.
close to the mic.
Okay,
But you have to present your case.
I have to present my case, okay.
You
News to
gave a
me.
ticket on-
Summons on 7/25/23
Perfect.
for black Porsche on Dakota Avenue. It's Kentucky plate 3348 Charlie Sierra for overtime meter.
And for purpose of the record, I have received and reviewed the documents that were sent to me electronically for this case. Do we have a respondent for this case present in the audience?
No, ma'am.
No respondent?
No, ma'am.
Okay, what is the city requesting? What is the town requesting?
The town's asking for a fine of $77 plus an administration fee of $175 for a total of $252.
I will hereby find, based on the evidence presented and the records provided, that the violation stated in that citation did exist, and as such, I am imposing the fine of the $77 and the administrative fee requested by the city in regard to fees and costs incurred regarding this matter in the amount of $175 for a total of $252, which shall be paid within 30 days. All right, next case.
Next case, Douglas Vopel, Officer Mike Surik.
You have the citation number? I have two of them. I have two different ones. Which
Members, speak
citation
close to
number is
the
it?
mic, please.
This one was 707-34790.
Okay. All right, it looks like on July 22nd, at about 4:30 p.m., I had occasion to be at on Old San Carlos when I noted a vehicle having a Florida tag. Ida Sam 44 Robert Adam. It was parked in space number 12, number 12, and according to the app on my phone, they had not paid for parking, or the parking had expired.
I'm sorry, did you state your name and relationship to the case when you first started the case?
Yeah, my name is Mike Surek. I'm a base supervisor, of the town of Fort Myers Beach. So the town is asking for a fine of $77 plus the administrative fee of $175, totaling $252.
Right, and the citation was left in the car itself?
Yes, it was, ma'am, on the windshield.
All right, do we have a respondent present for this regarding this matter?
There's no one present.
No?
No,
No.
not present.
Okay. Okay, great. Alrighty, I hereby find that there was proper service and that the violation as stated in the citation did exist, and as such, I'm imposing the one-time fine of the $77 and granting the city's requesting the amount of $175 regarding fees and costs incurred regarding this matter, and bringing it to magistrate. That totals $252, which shall be due and payable within 30 days.
Thank you.
Okay, next case.
Next case is Jessica Cartier. It was reference number 714-00206. That has been paid.
Next case.
The next case will be William Alcantara, reference number 700-42151. David Scott will present.
David Scott, Fort Myers Beach base officer. Sums occurred on 5/29/23. It was prohibited by sign. Florida registration 82 Alpha Echo Golf Lima. Red Nissan on I Street for prohibited by sign. What's that?
We have somebody present on behalf of the respondent?
No one present, ma'am.
No? Nobody present.
The town asked for a fine of $77 plus an administration fee of $175 for a total of $252.
All right, I hereby find that there was proper service and that the violation as stated in the citation did exist, and as such, I'm imposing the one-time fine of $77 and granting the city's request in the amount of $175 for fees and costs incurred regarding this matter, for a total of $252, which shall be paid within 30 days.
You can stay
Next
here.
case.
Next case will be Mohammed Fahaj. It was reference number 700-43083. David Scott will present for overtime meter.
David Scott, base officer, Fort Myers Beach. Sums occurred on 6/27/23, overtime meter, Ohio plate, Papa 973649, overtime meter, black Chevy on Old San Carlos Boulevard. Town asked for a $77 fine plus an administrative fee of $175 for a total of $252.
Okay, the citation was left in the vehicle.
Yes, ma'am.
All right, do we have anybody here on behalf of the respondent?
No, ma'am.
All right. I hereby find that there was proper service and that the violation stated in the notice of violation did exist, and as such, I'm imposing the one-time fine of $77 plus the administrative fees and costs incurred by the city regarding this matter in the amount of $175 for a total of $252, which shall be paid within 30 days.
Thank you.
Next case.
Next case is Mohammed Fataj. It was reference number 7033484. Officers Bob Monahan, overtime meter.
Good morning. I'm Bob Monahan from the Fort Myers Beach base. Issued a ticket on June 27, 2023 to Ohio registration.
Little closer to the mic, please.
I'm sorry.
Just a little closer to the mic. Thank you.
Bob Monahan from Fort Myers Beach base unit. On 6/27/23, I issued a ticket to Ohio registration P Papa 973649 for an overtime meter on Old San Carlos. And it was meter number 18, and it was a black Chevy pickup truck.
All right, the citation was left in the vehicle.
I'm sorry?
And do we have a respondent?
No, nobody's here.
No respondent?
No, ma'am.
All right, I hereby find that there was proper service and that the violation as stated in the citation did exist. And as such, I'm imposing a one-time fine of $77 and granting the city receipts requesting an amount of $175 in regards to fees and costs incurred by the city regarding this matter, for a total of $252, which shall be paid within 30 days.
Thank you.
Thank you.
Next case is Maria Fernanda Rose, overtime meter, reference number 71402166. It has been paid.
All right, next case.
Next case, Veronica Mary Gibson, obstruction of roadway, reference number 712-02224. So Bob Gonzalez will be the officer.
Hi there.
The officer has to present first.
Who's going to present first, ma'am? So the
Oh.
code officer, and then
Oh.
we'll go ahead and have you come up afterwards.
I'm
Okay?
sorry. He'll present first and then you.
Okay. Thank you.
Good morning. My name's Saba Gonzalez. I'm here for citation number 71202224. Citation was issued 5/12/2023 on a Florida plate 02DDLW. It's a white Audi, and I wrote it for an obstruction of the roadway. It was parked on 5th Street.
All right, and
The town-
citation, was it left in the vehicle?
I'm sorry?
Citation was left in the vehicle.
Yes, ma'am. Sorry.
I'm reviewing the ordinance really quickly. Let me hear from the respondent.
You may get up now.
Now, come on up, please state your name and relationship to the case, please.
Hi there. I'm Veronica, the respondent. So I was the owner of the car, but I didn't have possession of it. I was living with well, he was living at my house. I was engaged to him. I kicked him out. Sorry, it's really traumatic, but he wouldn't leave, and he finally agreed to leave if I signed my car over to him, which I did, and I have proof. It's signed on May 10th. I have a copy of the title. I have a copy of the bill of sale dated the 10th. I have text messages. I was trying to get him to give me my license plate. I have text messages showing this. He finally ended up sending me my plate to my house. And what he did, I found out after the fact, he never had a driver's license. And now last week I found out he's got 2 cases against him. This guy's pushing 60 years old, and he's got 3 kids, 2 different moms that he's never paid child support for. These kids are 30. And he still has these open cases in Indiana, and he has no driver's license. So what he did is I found out, I called the police in Fort Myers where I live and spoke with an officer, and he said, ma'am, this car is no longer in your name. This was like a week later. And I said, that makes no sense. Well, what he did, when I signed the title over, I wrote his name on the top, you can see here. But he said, I'm not sure where I'm moving yet. He told me not to put the address in. So I gave him the title like that. And then what he did, since he didn't have a driver's license, he couldn't get the car in his name. So he sold the car He told me that it wasn't in his name or my name at that time. So what he did, he signed it over to the next buyer. So it went directly from me to the next buyer and kept himself out of it. And so he finally mailed me the license plate. I bought another vehicle, put the plate on that, registered it and all that. I have everything signed on the 10th. He got the ticket on the 12th. I didn't know about the ticket because I didn't have the car. So I got a final notice in the mail and I called and he told me it was parked, and I saw pictures. It was parked on the wrong side of the street by Margaritaville. And another thing is I work at Snug Harbor. I park there for free whenever I want. And so he had possession of the car. And then I've got text messages saying, when are you going to send me my plate? I need my license plate. I was afraid he'd be a jerk and who knows do what with it, but he did mail it to me. I kept saying, what are your plans with the car? Where's my license plate? He's moved twice since then. That was May. I've been doing detective work. I've got his new address to send the citation to if you want him to pay for it. But so it said that there was a ticket for $77 and then it said now it's $100 owed on this final notice. And that's the first I heard of it.
So, do we have the city attorney present? The town attorney present? Because it seems like you have some documents that you might want to go ahead and take a look at. Because the city, the way that the city's knows whose car it is by the registration. So based on what I'm hearing you say, you transferred the title of the vehicle prior to the ticket being issued, but the car remained registered under your name, and there's no record of him ever registering a car.
Right, because he doesn't have a driver's license. He has an ID card from Indiana. So it went.
Let me go ahead and have the town attorney review that. It seems to me that it might be a civil issue that you might have, but let me give the opportunity to the town attorney to go ahead and review the documents and see what the city's position is.
Okay, it looks like it was transferred as of 5/10/23, and the ticket was when? 5/12. 5/12. So I didn't know about the ticket.
I can barely hear you, for the town attorney. So a little closer to the mic.
Is this working?
I can't see you either.
Yes.
Okay. I don't know where they, okay. The certificate of title was transferred 5/10/23. So it doesn't look like she owned the car at the time of the violation.
He just hadn't sold
Missed
it yet.
that part.
You know, we can just, I believe that we will withdraw this, and now that we know who owned it, we can notice this person.
He had Michael back, that's his name. He had possession of it for about a week, and then he's stupid. He put stuff on social media. He said, sold the car for $2,700 today. I paid $8,000 cash less than a year before that. And, oh, my new ride, posted an electric bike because he doesn't have a, so, I mean, so he literally was driving the car for about a week and then sold it. But he had the title, he had, by that time then he just parked it.
Okay, the town will withdraw.
Okay.
Thank you.
Yeah, 'cause
You can keep all that. Okay.
Next case, Michael Allen Duval, parking prohibited. Reference number 707-30505. The officer will be Mike Sherwin.
Yes, Your Honor, my name is Mike Surik. I'm a Fort Myers Beach-based supervisor. On May 12th, 2023 at about 09:59 hours. I had occasion to be in the area of Estero Boulevard in Old San Carlos. I happened to notice a large 18-wheeler delivery vehicle being unloaded, and adjacent to it, parked in a prohibited parking zone where it's posted no parking, illegal, or immediate loading and unloading only. I saw ends up being a silver Honda having Florida plate Henry Frank Sam 12. It was parked in that area, in that loading zone adjacent to the sign. So I circled the block, went about my business, came back about 10 minutes later, the vehicle was still there, so I issued a citation to that vehicle for prohibited by sign parking.
Right, we have a respondent.
Yes, ma'am, we do.
Audience.
Mr. Val, step up.
Go ahead, that's the 77 and the, Go ahead and say your name.
Hi,
and the
my name
business
is Mike
you're in,
Duval,
please.
and I'm the respondent. I just wanted a backstory, a little bit of how this transpired and started. I sell food. I was there with my truck. We had gotten there. Bella Mozzarella was just getting ready to open, so we had their food on our truck. Our truck was originally there at 7 o'clock in the morning. They weren't there. We used to have what's called a key drop. We had a key. We could go in there, put their food in, and then leave. After the hurricane, that was obviously wiped away. So we came back, and myself and then another van, which was from my company, was also there helping unload the truck. Meanwhile, while I was getting him a new form to fill out to have a key drop and just to pick up a check. When I came out, this officer was there and he was writing me a ticket. And I said, "Hey, we're here unloading." He said, "I timestamped you. You've been here longer than 15 minutes. I'm like, "Yes, sir. We're unloading. We have 95 cases of food to unload to this account." And meanwhile, as we're talking about that, he's getting ready to give our van a ticket as well, who was also in that loading zone trying to help and unload this food to an account that was trying to get up on their feet. He kind of got upset with me. I got a little bit upset with him. I said, "All we're trying to do is get Fort Myers Beach back and running. I've been here for 7 years on Fort Myers Beach working, never had a parking ticket, never had a speeding ticket. All I was doing is trying to help get our food into the restaurant."
All right, response from the city?
Could the code officer please come forward? Okay. And could you explain exactly what code provision they were violating?
Well, the truck was being unloaded, no question about it. And I believe that the respondent, the man that was just here at the podium, was helping unload it. However, the other vehicles that were parked, and he indicated there was a van there also, they were parked there and there was no loading or unloading going on with those vehicles. As a matter of fact, a 18-wheeler Bud Light truck pulled up and had to park in the street and partially block traffic because it could not park in this immediate loading and unloading zone. They were legitimate as far as the unloading of the truck that they were unloading, but the two vehicles were parked, including the one that I issued a citation to. There was no unloading or loading going on, which prohibited another vehicle from being able to handle its normal operation. That's why I issued a citation.
Okay. Please.
His statement to
Is
me
that
was,
right?
he timestamped me for 15 minutes. There was no mobile activity, so therefore he issued me a ticket. I have one of the other people, I have him put me a video citing the same exact thing, that he timestamped me for 15 minutes, and that's why we got a ticket. Not because we were there in the no parking zone or the unloading zone, which we were unloading, and I had also unloaded stuff from my car there and then helped unload the rest of the truck to get it speedy recovery. Our truck's 40 feet long. It has a 20-foot ramp. The tractor trailer wasn't going to fit there afterwards in there anyways until we were gone. Therefore, we were helping get that stuff unloaded quicker than just being there parked.
Okay, were you actively loading and unloading?
Yes, ma'am.
For those 15 minutes, which there's in the ordinance, there is no statement regarding the amount of time, but let me hear from the city, from the town attorney.
Were you loading and unloading the entire time?
Yes, ma'am. And he said that there was no activity for 15 minutes. It's impossible. We were there at 9 o'clock in the morning. It took us about 50 minutes. We finished unloading it, and literally as we went in to collect a check and walk out is when he was standing there writing us a ticket. He told us he timestamped us for 15 minutes, And that's why he gave us a ticket, not because I was parked there. Those were his exact words. That's what one of the other guys have. I had the third guy there that I didn't ask for a statement because I figured one would have been enough. And that, I mean, it was $77. I could have not fought. I could not fought and paid the $77. I just feel like it was wrong. I was there literally unloading and loading.
Could the code enforcement officer come up?
All right, the timestamp photo, and I don't have it, I wish I did. What I do is I take a photo, a timestamp photo that shows the time that I go by so I can remember. So I can remember what time I last saw the vehicle parked there. Then when I came back again, it was 15 minutes later, the vehicle was still sitting there. There's nothing being loaded or unloaded from those two vehicles. The immediate loading and unloading has to do with a vehicle that's being loaded or unloaded. There's an adjacent parking lot which is free, that's 15 feet away. They could have parked in. The Bud Light truck could have fit in there. That's what it's meant for, loading and unloading, not parking other vehicles there while you load and unload a different one. That's why the violation occurred, and that's why I issued the citation. That's all.
Okay, I believe,
And I should mention, the town of Fort Myers Beach is asking for a fine of $77 plus administrative fee of $175, totaling $252.
All right, so this is the part of the hearing that I have to remind people that my job here is to take the facts as they are presented and apply the ordinance as it's written. So I don't get to rewrite the ordinance, and I don't get to change the facts or even massage the facts. Unfortunately,
I don't know if you can hear us, but we lost you.
all right, so looks like I'm back. Okay.
We lost you again, ma'am. Oh, you're back.
could you start?
I know it's on your end because I have super fast internet.
The resort. I apologize.
All right, there's the part where I have to apply the
We seem to be having problems hearing you. Would it be
as it
possible?
was written.
Okay,
As such, I'm gonna find that there was proper service and that the violation as stated in the citation did exist. And as such, I'm imposing the one-time fine of $77 and the fees and costs requested by the city in the amount of $175 as incurred by the town regarding this matter.
May I just say one more thing, please? He just stated as well that he timestamped me and he gave me a ticket because I was there but not moving for 15 minutes. He didn't give it to me for not unloading and loading. He gave me the ticket because he timestamped me and said that I wasn't there for 15 minutes. That's why I'm here fighting this, not because my car was not there. I'm fighting because he tells me that I wasn't there for 15 minutes. That's why he gave me the ticket. He just said it himself again.
Now, I understand that, but again, like I said, I have to take the facts and the ordinance and put those together. And based on the facts that I have, the vehicle was there for 15 minutes. I have testimony from the officer, perhaps you might have been taking it in, whatever you were unloading in, but the car was parked for those 15 minutes. And those are the facts I have, and I have an ordinance that says you were supposed to be parked there. So unfortunately, I have to mesh those two things, which leads me to the ruling that I have to uphold the citation amount, and hence my order imposing the $77 and the $175 in fees and costs.
Do you have amount of time, ma'am, for the fine?
Yep. Next case?
Did you say 30 days for the fine, ma'am? I didn't hear.
I'm sorry?
How much time for the fine? 30 days?
Oh, 30
payment.
days. The 30 days, yeah, it's always 30 days.
Thank you.
That's for the total of the 252.
That was- Hey, ma'am, the next case is a
Next
motion,
case?
I'm sorry?
Go ahead, next case.
Yes, the next case is motion for rehearing, Prasad Properties, Florida Investment LLC, reference number 2022-0462.
Good morning, Sarah Spector with Retzel and Andrus on behalf of Prasad Properties. This case is a companion case, I don't know that it's been called that, but a companion case to 20220655. It's the same violation, just two different property addresses. Would you mind if we consolidated those for purpose
Well,
of this?
what I'm hearing now, let me go ahead and this might save all of us some time. This matter, if it's coming for a rehearing, that is not the proper procedure for this to come back. It would have been an appeal which had to be done pursuant to the statute within 30 days. And I remember these cases very well. And we're well past those 30 days. That should have been something taken to the circuit court, and it's not something that would be within my purview to go ahead and have a rehearing on. The ruling was entered, and the proper procedure would have been to take it to as an appeal to the circuit court.
To that point, the Land Development Code in Section 2-428 specifically provides the option of requesting a rehearing if that is filed within 10 days of the rendition, and it was so filed.
When was it filed?
It was filed on July 28th. All three were
Of this
filed.
year?
No, of 22. We filed this in July 28th of 2022, and this is our
Okay.
first hearing on it.
2022, executed on the 15th day of July.
Thank you. Yes, it was, while the hearing was on the 30th, the actual order was not issued until July 15th.
Right.
And I was going to
Go ahead
recite,
and do your presentation.
okay, I was going to recite
You have
some
a seat.
history just to bring you up to speed as to where this was. Like I had started with, there are two identical cases just for different properties. Whether it's appropriate or not, I'm just going to repeat the same thing for the next case if you don't want to consolidate these, which is fine.
Let's go ahead and have the town go ahead and call that second one, and then we'll hear them both simultaneously.
Okay. Right now?
The second case is 2022-0655, 1046 Estero Blue.
Perfect, thank you. At the outset, I want to make certain that it is clear on the record that these motions for rehearing, which were timely filed pursuant to Section 2-428 of the town's Land Development Code, were filed with the town on July 28, 2022. On August 1st of 2022, the then town attorney acknowledged receipt of the motions and noted that the town would be filing responses to same. Understandably, the motions for hearing were not scheduled for hearing for some time. Yet it was quite the surprise when we were reviewing the April 20th, 2023 special magistrate agenda and saw that the Prasad cases were included as lien imposition cases without ever having ruled on the motions for rehearing, and furthermore without providing any notice to Prasad. When questioned about this, the town attorney again indicated that the town was preparing responses to our motions for rehearing and agreed to remove the cases from the lien imposition agenda. At that time, we were also advised that the cases would be moved forward to the May 2023 agenda. However, they were not placed on that agenda and instead were placed on the June 15th, 2023 agenda, which Prasad was not made aware of until June 13th, 2 days before. Again, after being questioned about this, the cases were removed from the agenda, which is what brings us today's hearing. While there have been two previous mentions of filing a response, we have yet to see one. And while the town knows our position because we filed motions for rehearing, we haven't seen anything or heard anything from the town as to its position. So I just want to make that clear on the record that we provided our motion but saw nothing in response.
Okay, do you know whether that motion for hearing was also sent to me?
Was it sent to you?
Because I don't recall having received it, but based on the timelines, again, if it was 2022, I might have not. If it came in, I never saw it, but my question to you is was it submitted to me?
It was filed with Daphne Bircher and John Herron, who both acknowledged receipt and that it was timely, and shame on me, I didn't confirm that they forwarded it to you. But I'm not allowed to have direct contact with you.
That's okay. I was just asking the question because I don't remember having seen it. That's why I asked, but you can go ahead
Okay.
and proceed.
Okay, so my next few points are what the motion for rehearing provides just in summary form. If you would like, I can provide another copy of these motions for rehearing so that you have an opportunity to see them. I don't know how you would like me to get them to you, but I'm happy to.
So as part of the rehearing, what I'm going to be looking for is what is new that is different from the first hearing that led to the order.
Well, what the Land Development Code provides as far as rehearing, there's two bases for which you can grant a motion for or a request for rehearing. Either it was contrary to the decision was contrary to the evidence, or the hearing involved an error on a ruling of law that was fundamental to the decision of the special magistrate. So it doesn't require anything new. It just requires that we show that either there was an error in application or the ruling was wrong.
Well, it is new because obviously if that argument wasn't raised at the hearing, that led to my order under both of those prongs. So my question to you is what's different this time around?
Sure, and that's what I'll go into right now. So as I mentioned, those are the two bases provided in the code. Here, it's our belief that the special magistrate should grant the motion for rehearing for two reasons. First, Prasad was denied fundamental due process, and the fines levied are unconstitutionally excessive. So I'll now briefly provide additional information regarding each of these. Fundamental due process requires a proceeding to be essentially fair. Here, Prasad was denied fundamental due process in at least two ways. First, he was denied a continuance without reason or explanation, which prevented it from meaningfully appearing and presenting evidence at the hearing. Second, Prasad was denied advance notice of the witnesses and evidence that the town intended to use against Prasad, which prevented Prasad and his attorney from adequately preparing for the hearing. Denying a continuance is generally improper when to do so would create an injustice for the moving party, when the need for continuance was unforeseeable and beyond the movement's control, and where the adverse party will not suffer any real prejudice. Here, the need for the continuance was unforeseeable and beyond Prasad's control because the town rescheduled the code enforcement hearing with less than 30 days notice to a date on which the principal of the alleged violator would be out of town. He had longstanding plans to be out of town for his son's wedding celebration, and this was noted in our request for a continuance. Despite the then town attorney's assertion, case law strongly supports providing the corporate officer with the most knowledge the opportunity to appear on behalf of the corporation. Whereas here, the then town attorneys asserted that any employee of Prasad could attend and provide evidence, which is just not true when Mr. Prasad is the one that has the most knowledge about the corporation and the alleged violation. Furthermore, it is not appropriate for the special magistrate to make a decision concerning a repeat violation based on his or her memory from a different hearing, which is again what the then town attorney had argued, was that you can simply rely on what has been said at previous hearings, but rather it must be based on actual evidence admitted in the record, which the corporate representative of the alleged violator is permitted to do by statute. The town could not have been prejudiced by a short continuance, especially since it had canceled its originally scheduled hearing, which was in March, and then waited 3 months to reschedule, and in doing so, provided less than 30 days notice. There was no evidence placed on the record that the alleged violation was causing a health, safety, or public welfare concern, and the fine of $500 per day was ostensibly continuing to accrue. So again, there's nothing on the record showing that the town would have been harmed by granting this continuance. Though evidence of a repeat violation was not placed on the record, there was in fact evidence supplied, evidence that Prasad was denied access to in advance of the hearing. This denial was based on the then town attorney's assertion that there is no discovery in code enforcement cases. Although neither Chapter 162 nor the town's code explicitly speak to discovery and a pre-hearing exchange of witnesses and exhibits, Florida courts have held that it is necessary to fill in the procedural gaps in Chapter 162 by the common sense application of basic principles of due process. Common sense dictates the meaningful opportunity to be heard requires being informed of all the facts and evidence before the hearing so that a party and their counsel can adequately prepare defenses for the hearing. All of these arguments led to the conclusion that the fine is unconstitutionally excessive, which is prohibited by both Article 1, Section 17 of the Florida Constitution and the 8th Amendment to the United States Constitution. A fine becomes unconstitutionally excessive under the Florida Constitution when it is so great as to shock the conscience of reasonable men or is patently and unreasonably harsh or oppressive. This standard is met with the fine when the fine is plainly and undoubtedly in excess of any reasonable requirements for redressing the wrong, or when the fine is unreasonably disproportionate to the gravity of the offense. And just so you know, I just did a little ellipse sign. All of this is case law that's cited in our motion. So I'm just, like I said, providing a summary of that. The analysis under the excessive fine clause in the United States Constitution is similarly driven by whether the fine is grossly disproportionate to the gravity of a defendant's offense. The fines here are unconstitutionally excessive as a result of treating the violations as repeat violations at $500 per day and because there's no cap in Chapter 162 that provides for a maximum cumulative fine. This is especially the case where no evidence was placed on the record that the violation was hurting anyone beyond mere technical violation of the ordinance, or that the violation posed a health, safety, or welfare concern. This fine, which as of the date of imposition was already $63,000, is more than fines for most crimes. For the reasons stated herein, the enforcement order should be vacated in its entirety. Alternatively, we would respectfully request the opportunity to present the underlying issues to you at a rehearing.
Okay, let me hear from the city attorney. Oh, I'm sorry, are you done with your argument?
On this case, yes.
Okay,
There's still
let me
one
hear
more.
from the city attorney.
I'm the new town attorney for the town of Fort Myers Beach. I was not presented with the paperwork that was just talked about here. Although I had talked with the attorney representing Mr. Prasad, you did not give me the paperwork with regard to your request.
May I respond to that?
Sure.
In the
I'm
first,
having a hard time hearing the town attorney. You're
Okay.
cutting off, so get closer to the mic, I'm sorry.
she was commenting that I didn't provide these documents to her, but I had originally asked for a continuance of this hearing, and in doing so, provided all three motions for a hearing by email. So I'm sorry she didn't receive it, but I've been going back to that specific email to pull the motions because I forwarded them in one of the three emails I sent.
Okay.
So it is
did
my
not
understanding
receive them,
that
so.
the town does have a new attorney, so I'm gonna ask her whether she wants to go ahead and have us proceed with the hearing today, regarding her hearing today, or whether you want to go ahead and have some time to review her motion for rehearing and speak with counsel before proceeding. So that I'm gonna put that with the town. It appears that the respondent's attorney is ready to proceed, but I also understand that you're new.
Okay, well, it's my understanding that you will be, you have resigned from your position. And so I'm not sure that are you going to be continuing to be the special magistrate, but by Zoom for a while? Because I don't know how a new special magistrate would deal with the rehearing matter.
So is the town requesting for me to go ahead and proceed with a ruling without hearing the town's position on it?
I guess my response would be different if I believed that you were going to be at least having one more special magistrate hearing, whether it's in person or.
I've offered, as you know, some of you already know, I've resigned from my position due to a change in personal circumstances. I have offered my services to the town to remain as magistrate until a replacement is found. So long as they're done by Zoom. I do not know if the next hearing is going to be presided by me or by a magistrate. I don't think that under either circumstances, it would really change much. I believe these are recorded. They're always done by Zoom. Anyways, done by Zoom even when they're in person. And there should be a recording of the proceedings. So I don't think the change in magistrate will really affect that. And again, it is possible that I'm the one who does the next one. So unfortunately, I don't have a crystal ball to know it either in either direction on either of those things.
Okay, well, yes, then I would request an extension.
Okay. Respondent, is that?
I'm sorry, but I asked for a continuance 2 weeks ago when this first came, and I had to prepare for today because I was told it was going forward. So Can you give me 1 second to consult?
Yeah, definitely.
I just want
Go-
to ask
go
my
ahead.
client real quick. We are understanding that there is a new town attorney, so we're willing to allow that. And I'm assuming that we do have one other case. Would that same thing apply to that other case?
And also a hearing?
Yes.
Yes, the other
Yeah,
one
and,
is,
let me confirm with the town attorney that she's not ready to proceed with that other case as well. Could you,
That is
is that
correct.
case number 202202?
Yes.
652.
So let me
652.
check with the town attorney what her position is in regards to that one, whether she wants to proceed with that one or she wants to request a continuance to be able to review the documents.
I am requesting a continuance on that one also.
And I'll make
Alright.
sure, I'll send these to you and then send you a separate message to say I sent them, so that if you don't get them, you
And
can
I'll
let me know.
acknowledge it.
Perfect.
Thank you.
All right.
Alrighty. Okay. Based on the hearing from by the parties, we'll go ahead and continue this one under the understanding that it might be me or it might not be me during the case, the hearing. Thank you. Thank you, counsel.
Thank you. Next case will be
All right,
imposition,
next case.
imposition of lien case to be heard. It's reference number 2022. Zero 0355. Kristen will present.
This is a lien hearing case for 5765 Water Street. The property owner is Wilfredo Rodriguez. We brought this to hearing last year and haven't certified the lien. It was for multiple daily, weekly rentals during a 1-month period. Per the order, we did a fine of $9,000 plus the $75 admin fee for a total of $9,075. The property is not renting at this moment, so it is in compliance, but they have not paid the fine. In my packet
Right, do
that
we
I,
have somebody here on behalf of the respondent?
yes.
Please give your name and relationship to the case, please.
Wilfredo Rodriguez. I'm the property owner.
Okay,
I wasn't here. This case is from last year, probably even longer. It was set for trial a few times. Then the hurricane came. And then that was all postponed. When it was set for court last time, I wasn't in town. I was out of the country. So I wasn't even here for that lien hearing or whatever hearing it was. That's why I'm here today. I wasn't here when it was rescheduled. I was not here at that time. I would have been here for the initial hearing. But then when it was postponed and rescheduled, that time came about and I wasn't present.
So I have the documents before me relating to the citation, the ruling, the order, which in fact was recorded, and the recording of that order was on July 22nd of 2022. And the hearing date was June 30th of 2022. The hurricane didn't happen until September of 2022. And we never received any rehearing, and it was not appealed. So at this point in time, that order stands. And as such, the time for any rehearing or appellate remedies has expired. The town has properly and procedurally dotted their I's and crossed their T's. And they have the right to go ahead and proceed with the certification of the order for it to become a lien against the property and proceed with foreclosure proceedings afterwards. If the fines are not paid.
Okay. Is there a way to appeal that now, to have another hearing at this point?
You had 30 days to go ahead and appeal it. Those 30 days are long gone, and those 30 days were well before, a month before the hurricane happened. So your time for appeal and a time for rehearing lapsed before the hurricane happened. So there really is no reason why we should be deviating from those dates.
Well, I mean, the property has been in
And
compliance.
Even if there were to be a deviation, it would be pursuant to any Florida Supreme Court order regarding any deadlines being extended as a result of a hurricane. But again, as I just stated, and as the record reflects, that order was before Hurricane Ian, and the time for the appeal was before Hurricane Ian. As such, the town has every right to go ahead and proceed with what they're requesting and to get my order.
Has it been approved after that date? So these are open. Okay.
Right?
Okay.
All right. Based on the evidence presented, I hereby find that the magistrate order from the June 30th, 2022 hearing has not been complied with by failure of making payment of fines accrued to date. And as such, I'm going to certify said order in the amount of $9,075, $9,075. And by certifying this order, it shall become a lien against the property and recorded in the public official records of the county order. Right? I believe that is the end of our agenda.
We have one more.
We have-
The next
Oh, we
case,
have one. Oh, wait, I missed it. Sorry, the new pieces, sorry. I have one more page.
the next case, reference number 2023-0656, which was 250 Old San Carlos Boulevard, has been continued. So the next case that will be presented by myself is reference number 2023 0641 222 Mango Street. I am Vincent Bird of Fort Myers Beach Code Compliance Manager. The address of the violation was 222 Mango Street. Violation number 2023-0641. On 4 or 5.
I'm gonna I'm gonna go ahead and stop you with continuing the presentation on that one. There might be a minor conflict, but I believe, I'm not positive, but I believe that these the property owners might be related to my ex-husband.
There may be,
which
I'm
would
sorry.
create a conflict.
Okay. Very good. We'll continue it then.
I don't know if they're present in the audience, but even in the abundance of caution, I think it would be wise for me to go ahead and not proceed, because if I enter an order, it can be validated for that reason. So I'm going to go ahead and recuse from that one.
Yes, ma'am, no problem. I agree with what you're offering.
What are the chances of that? But
Then the only case left, we withdrew reference number 2023-0552, 210 Redfish. They have a permit. We withdraw the case. And that is all we have.
so that one's been complied.
Yes.
Perfect.
Thank you very much.
All right. I believe That concludes our agenda. Thank you so much. I don't know if I will be seeing you guys in any future hearing. If I don't, it has been a pleasure.
Same here.
Serving the town.
It's been a
I am
pleasure.
at your service. Congratulations to Kristen on her new position. I'm very happy, and congratulations to the new staff, the town attorney. I know there's been some movement around a position, so congratulations to all of you.
Thank you. Thank you for everything.